Stop scrolling right now. Put down whatever you are doing and pay very close attention, because what I am about to share with you in the next few minutes could genuinely be the most important financial and medical information you receive this entire year. I am not exaggerating. I am not using a dramatic headline to get your attention and then disappoint you. What I am about to break down could put thousands of real dollars back into your pocket, protect your health, protect your family members, and safeguard everything you have spent a lifetime building. And the terrifying part is this: most American seniors will never receive a single dime of what they are now legally entitled to, simply because they will never fully understand what just happened in Washington. The United States Supreme Court has just delivered one of the most consequential rulings for older Americans in over a generation. In a stunning 8-1 decision, the highest court in the land has fully upheld and powerfully reinforced the legal framework of the Elder Care Bill, a sweeping piece of legislation that was moving through implementation across the country, but facing massive, well-funded resistance behind closed doors. 8 justices, 1 direction, a ruling so decisive, so sweeping, and so unambiguous that even the legal analysts who cover the Supreme Court for a living were calling it historic before the ink was dry. This ruling does not just preserve your existing protections, it supercharges them. It permanently closes the dirty legal loopholes that high-priced industry lobbyists were counting on to drain your savings. It completely destroys the delay strategies that billion-dollar pharmaceutical companies were desperately counting on. And most importantly, it establishes an unshakable constitutional foundation around your senior benefits that no future Congress, no corporate lobby, and no team of industry lawyers can quietly strip away without facing immediate and devastating legal consequences. If you are over the age of 60, if you are currently caring for an aging parent, if you are approaching your retirement years, or if you are already living month to month on Social Security and Medicare, this single ruling directly impacts your wallet, your health care, your housing, and your financial survival. Grab something to write with. Call your spouse into the room. Text your adult children and tell them to pay attention, because what I'm about to break down affects their parents, their future, and frankly, their financial security too. But first, here's the part that should make you absolutely furious. The mainstream media threw out a dry, generic headline: Supreme Court upholds elder care framework 8-1. Then they immediately moved on to the next political story. Why? Because keeping you in the dark is highly profitable for the massive corporations that just lost this legal battle in the highest court in the country. Meanwhile, millions of vulnerable retirees are sitting at home right now with absolutely no idea what is now constitutionally protected, what they are legally entitled to receive, or what urgent deadlines are already ticking that could cost them everything if they do not act in time. Because here's what the Supreme Court ruling did not do. It did not automatically enroll you in these newly protected benefits. It did not drop an extra check into your mailbox. It did not call your insurance company to lower your premiums. The Supreme Court built the legal foundation, but you still have to walk across the bridge and claim what is yours. Many of these benefits require you to file an application. Some have enrollment windows. Some require you to update your records immediately. If you miss those windows, you lose your access entirely until the next cycle opens. That is exactly why we are breaking all of this down today, layer by layer, in plain English, with no legal jargon and no political spin. Let us start with the change that is already sending shockwaves through the entire pharmaceutical industry: prescription drug pricing reform. If you are currently on Medicare, or if you are managing the health care of an aging loved one, this is the news you have been waiting your entire retirement to hear. For decades, Medicare, which stands as the absolute largest purchaser of prescription medications in the entire United States, was legally prohibited from negotiating drug prices directly with pharmaceutical companies. Let that sink in for a moment. The single biggest buyer of medications in the entire country was banned by federal law from using its massive purchasing power to bring prices down for the citizens who needed those drugs to survive. Private insurance companies could negotiate freely. The Department of Veterans Affairs could negotiate freely, but Medicare, which currently covers over 67 million Americans, was forced by law to pay full, inflated retail prices. The result was predictable and heartbreaking. American seniors were paying 2, 3, sometimes 5 times more for the exact same medications that seniors in Canada, Germany, Japan, and Australia were getting for a fraction of the cost. The identical drug made by the same manufacturer, just with a different zip code attached to the purchase. The Elder Care Bill stepped in and legally mandated aggressive drug price negotiations. But what did the pharmaceutical industry do? They launched an absolute onslaught of federal lawsuits across multiple states, desperately trying to gut those negotiation provisions and have them declared unconstitutional before they could fully take effect. There were active, dangerous legal challenges working their way through the federal courts, all aimed at stripping these savings away from your monthly budget. With this 8-1 Supreme Court ruling, those corporate challenges are not paused. They are not sent back to lower courts for reconsideration. They are legally permanently dead. What does this mean for your daily life? If you are currently spending $200, $300, $400, or even $500 a month out of your own pocket on medications for diabetes, heart disease, high blood pressure, arthritis, or high cholesterol, there is a very real and definitive chance those costs are about to drop significantly, not someday in the distant future. On a rolling schedule that is now constitutionally confirmed and legally accelerated, the ruling also upholds the annual out-of-pocket drug cost cap for all Medicare beneficiaries. There is now a permanent, constitutionally protected legal ceiling on what you will ever pay in a single calendar year for your life-saving medications, no matter how many prescriptions you fill and no matter how expensive those drugs are. For seniors managing multiple chronic conditions, this cap alone can mean thousands of dollars saved every single year. What do you need to do right now? Do not wait for your pharmacy or your insurance plan to notify you, because they are in no hurry to slash their own profit margins. Call your Medicare Part D plan administrator directly and ask 2 specific questions. First, what is my updated annual out-of-pocket maximum for this year? Second, which of my current medications are now subject to negotiated pricing and what is my new cost? Verify everything. If you have been hesitating to fill a critical prescription because of the cost, call today, reference the Supreme Court ruling, and demand to know exactly how these changes affect your specific medications right now. Now let us talk about Social Security, because this is the section that gets people absolutely fired up, and rightfully so. Social Security has served as the financial backbone of American retirement for generations. It was designed as a sacred promise between the government and its citizens. You work hard, you contribute faithfully, and when your working years are done, the system takes care of you so you can live with dignity. But over the past several decades, that promise has been quietly eroding in a very specific and very costly way. Every year, Social Security benefits are adjusted for inflation through what is called the Cost of Living Adjustment, or COLA. The idea is simple. As prices rise, your benefits rise with them, so your purchasing power stays stable. In theory, a reasonable system. In practice, it has been failing seniors in a mathematically devastating way. The inflation formula used to calculate COLA tracks the spending habits of urban wage earners, working-age people who spend significant portions of their income on gasoline, consumer electronics, commuting, and work clothes. But seniors do not spend their money like a 35-year-old commuter. Seniors spend disproportionately on healthcare, prescription medications, in-home assistance, and utilities. The exact categories that have been rising in price faster than almost everything else in the economy for the past 2 decades. The result has been that seniors were technically receiving inflation adjustments on paper, while actually falling further behind in real purchasing power every single year. You were getting a modest raise, but your medical bills and your grocery bills were outpacing it by thousands of dollars annually. The Elder Care Bill aggressively addressed this injustice by replacing the rigged formula with a senior-specific inflation index, one designed to actually track how older Americans spend money rather than how a working-age city dweller does. Industry groups challenged this provision in federal court, arguing that Congress exceeded its authority. 8 Supreme Court justices just told them they were completely wrong. Your annual Social Security adjustment will now be calculated based on what your life actually costs to live, not what someone else's life costs. Yours. On your medications, your doctors, your utilities, and the real expenses of your actual daily life. Over time, even a modestly more accurate adjustment compounds into something enormous. We are talking about hundreds of additional dollars per year that over a decade of retirement adds up to thousands of dollars in benefits you would never have seen under the old formula. The ruling also upholds provisions strengthening Social Security's long-term financial stability by ensuring that higher income earners contribute proportionally more, protecting this system not just for you today, but for your children and grandchildren. What do you need to do right now? Log into your account at ssa.gov and review your benefit statement carefully. Verify that your recorded earnings history is accurate, because errors in earnings records are more common than most people realize, and they directly affect your benefit calculations. If anything looks incorrect, contact the Social Security Administration immediately and request a formal administrative review. Do not sit in silence and assume everything is being handled correctly. Let us move to nursing home reform, because this part of the ruling is receiving almost zero media attention, and it is absolutely critical for the safety and survival of our most vulnerable loved ones. The reality of nursing home care in America has been one of this country's most heartbreaking and least discussed failures. Federal inspection reports have repeatedly shown that a deeply troubling percentage of nursing homes have been cited for catastrophic safety violations. Dangerously inadequate staffing where a single overworked aide is responsible for an entire floor of residents who need real care and real attention. life-threatening medication errors, deplorable sanitation conditions, and in the worst cases, outright abuse of some of the most defenseless people in our society. The corporate nursing home industry fought back against every attempt to impose meaningful safety standards. They flooded federal courts with lawsuits, arrogantly claiming that basic caregiver-to-resident ratio requirements were administratively overreaching and economically burdensome to their profit margins. 8 Supreme Court justices rejected every single one of those arguments. Under the now constitutionally confirmed provisions, any nursing home that receives Medicare or Medicaid funding, which is essentially every nursing home in America, is now subject to mandatory minimum staffing requirements that are fully legally enforceable. Your parent, your spouse, your grandparent will have access to a real, properly trained caregiver when they need one. Not a promise on a brochure, a legal requirement backed by meaningful consequences. Those consequences are where the real transformation lives. In the past, fines for safety violations were so pathetically small that corporate chains treated them as just another predictable cost of doing business. They would rather pay a minor fine than hire adequate staff. That calculation has permanently changed. Fines are increasing dramatically, and repeat offenders now face the ultimate financial consequence, losing their Medicare and Medicaid funding entirely. For most facilities, losing that funding does not create a financial setback. It ends the business. That creates an entirely different level of motivation to actually comply. Transparency requirements are now fully enforced as well. Every facility must make its inspection reports, staffing ratios, and complete violation history publicly available and easily accessible online. When you research a care facility for a loved one, you will see the real story, not the glossy marketing material they hand you at the front door. What do you need to do? If you have a family member in a nursing home right now, visit Medicare.gov today and use the nursing home comparison tool to pull up that facility's current inspection reports and staffing data. If anything raises concerns, you now have stronger federal legal standing than ever before to demand accountability and to report violations to your state's long-term care ombudsman. Now let us pull back the curtain on elder financial fraud, because this is a silent epidemic that is robbing American seniors of tens of billions of dollars every single year. And here in 2026, the tools available to the criminals running these schemes are more sophisticated and more dangerous than ever before. The schemes are everywhere. Fake calls from people impersonating IRS agents demanding immediate payment to avoid arrest. Medicare fraud billing for services never rendered. Complex investment scams promising guaranteed returns. Heartless romance scams that prey on widowed seniors over months of carefully cultivated fake relationships before the request for money arrives. Crooked contractors who take a large deposit for home repairs and completely vanish. And tragically, family members or paid caregivers who exploit the access and trust they have been given to drain accounts. When the Elder Care Bill was drafted, it included aggressive fraud protection provisions requiring financial institutions to implement mandatory reporting and active intervention protocols. The banking industry fought back in court, arguing those requirements imposed excessive compliance burdens on their operations. 8 justices disagreed completely. Banks and credit unions are now legally required to have active protocols for identifying and flagging suspicious activity on senior accounts. A sudden large unexplained withdrawal, repeated wire transfers to unfamiliar destinations, a new name suddenly appearing on an elderly customer's account. These are now official federal red flags, and financial institutions have both the legal mandate and the liability protection to intervene, rather than simply process the transaction and move on. But you need to hear this warning clearly, because the threat is real, and it is accelerating right now. Within hours of any major ruling affecting senior benefits, scammers are already on the phone. They are calling seniors today, claiming that because of this Supreme Court ruling, you must pay an immediate processing fee to unlock your new benefits. They are sending emails that look exactly like official Medicare communications asking you to verify your account information. They are using artificial intelligence to clone the voices of real government officials. They are referencing your real name, your real address, and partial account numbers obtained from data breaches to make their calls sound completely legitimate. Listen very carefully. Legitimate government services are always free. The Social Security Administration will never call you out of the blue demanding immediate payment, wire transfers, or gift cards. Medicare will never ask for your credit card number or bank account information over the phone to process a benefit change. If you receive any call, text, email, or visit from anyone claiming to help you access new benefits related to this ruling and they ask for money or personal information, hang up immediately. Close close the browser. Then call the official number you find yourself directly from the official government website, not a number they give you, one you locate yourself. Write down this number right now, 1-833-FRAUD-11. That is the National Elder Fraud Hotline. Put it on your refrigerator, save it in your phone, and share it with every senior you care about. Let us also address home modification assistance because for most seniors, the ability to remain safely in your own home is not just a financial preference. It is your dignity, your independence, and your quality of life. The home modification programs embedded within the Elder Care Bill were challenged in court on funding mechanism grounds by opponents determined to kill the legislation. The Supreme Court completely rejected their arguments, upholding the full funding and implementation structure. Eligible seniors can now access financial assistance to install wheelchair ramps, widen doorways for mobility aids, add grab bars and walk-in showers, improve home lighting to reduce fall risks, and modify kitchens for safety and accessibility. These are not luxury renovations. They are life-changing safety modifications that can be the difference between staying in your own home and ending up in a care facility. When you consider that nursing home care can cost $8,000, $10,000, or even $12,000 per month, keeping a senior safely at home through modest federally backed modifications is not just the compassionate choice. It is the economically rational one for families, for seniors, and for the entire healthcare system. And do not overlook what this ruling confirms for dental, vision, and hearing coverage. Original Medicare has carried a medically indefensible gap for decades by excluding these fundamental services. Untreated gum disease is directly and clinically linked to increased risk of heart disease and accelerated dementia. Vision problems that go uncorrected lead directly to falls, which are one of the leading causes of serious injury and death in older adults. Hearing loss that goes untreated is one of the single strongest known risk factors for cognitive decline. Hearing aids routinely cost between $3,000 and $7,000 out of pocket. Dental work can cost several thousand more. For seniors on fixed incomes, these costs are not just inconvenient. They are completely inaccessible, and the health consequences of going without are severe and well documented. Provider groups and insurance industry representatives challenged the dental, vision, and hearing provisions, arguing implementation timelines were unworkable and costs were unsustainable. 8 Supreme Court justices found otherwise. New federal subsidies will help Medicare beneficiaries afford hearing aids. Pilot programs expanding dental care access through federally qualified health centers are moving forward with full constitutional protection. Funding for community vision services is increasing. This is a major step toward treating the whole health of older Americans rather than treating their bodies from the neck down. Now let me say this as directly as I possibly can, because everything you have heard today only matters if you act on it. The Supreme Court ruling is the foundation, but the benefits do not automatically appear in your account. They do not arrive in your mailbox. Many require you to apply, some have strict enrollment windows, and if you miss those windows, you may have to wait an entire calendar cycle before you can access what you are legally entitled to. The senior who takes action this week is going to find themselves in a fundamentally different financial and medical position than the senior who watches this, nods along, and then goes about their afternoon without making a single phone call. Here's your action list. Start today. Log into your account at ssa.gov and verify your benefit information and earnings history. If anything looks incorrect, contact the Social Security Administration immediately and file a formal request for review. Call 1-800-MEDICARE and speak with a representative about how the prescription drug pricing changes and the annual out-of-pocket cap apply to your specific plan and your specific medications. Schedule a free appointment with your State Health Insurance Assistance Program counselor, known as SHIP. This service is available in every state. It is completely free, and the counselors exist solely to walk you through changes exactly like these and identify every benefit you are entitled to based on your individual situation. They have no financial interest in what they recommend. Visit Medicare.gov and check the updated inspection data for any nursing home or care facility where you or a loved one currently receives care. Contact your bank this week and ask specifically what elder financial fraud protection protocols are now in place on your accounts. Set up real-time transaction alerts. Visit eldercare.acl.gov to find your local area agency on aging and ask about home modification assistance programs available in your zip code. Call your Medicare plan and ask specifically about your enhanced dental, vision, and hearing benefits for this year. I also want to address this honestly. This Supreme Court ruling is not a magic solution to everything that needs fixing for aging Americans in this country. No court decision, no matter how sweeping or how historic, can instantly repair decades of systemic failures. Implementation takes time. There will be friction. The pharmaceutical industry, the negligent care facility operators, and the financial predators will not simply comply with the full spirit of these protections willingly and immediately. They will look for workarounds, they will push on implementation details, they will lobby for weaker enforcement at every level they can reach. which is exactly why you cannot afford to be passive about this. The strongest protection any legal ruling has is a fully informed public that understands what is at stake and refuses to let their rights be quietly eroded. Knowledge is power. Your awareness is a shield, not just for yourself, but for every senior in your community. Share this with every person you care about. Call your neighbors, text your adult children, post it in your community groups, your church networks, and your neighborhood forums. Because the more people who fully understand what this ruling actually means, the harder it becomes for anyone to chip away at these protections without the public demanding accountability. The Supreme Court did its part. 8 justices spoke with one clear and powerful voice. Now it is your turn to do yours. The benefits exist. The protections are constitutional. The only thing standing between you and everything you are now entitled to is the knowledge to ask for it and the decision to go get it. Do not wait. Start today. Because 30 days from now, the seniors who acted will be in a completely different position than the seniors who did not. And you deserve to be on the right side of that line. If this helped you understand something important about your rights, your benefits, and your future, please share it right now with every senior you love. Hit that like button and subscribe so you never miss a critical update like this one. This is exactly the kind of information that changes lives when it reaches the right people before the deadlines pass. The clock is already running.